I'll now call on my next speaker. This time is a discussant, Professor Suzanne LALONDE. Dr. Suzanne LALONDE is a full professor of international law and the law of the sea at the law faculty of the University of Montréal. She holds a BA from the University of Ottawa, an LLB from Queen's University, and a PhD in public international law from the University of Cambridge. Her research and publications in both French and English focused on core international legal principles, especially those pertaining to sovereignty and determination of boundaries on land and at sea, with a particular emphasis on the Arctic. She was a member of the ILA committee that reported on baselines under the law of the sea in 2018, and co-editor of Ocean Development and International Law from 2017 to 2018. She is a member of the Canadian Arctic Security Working Group. Professor LALONDE, you have the floor.
It's an honor to be able to participate in such a prestigious and important meeting. And I would also like to extend my thanks to the Ministry of Foreign Affairs, to the Korean Society of International Law, to ICLOS, for this amazing conference and just the platinum standard of conferences, I must say. I think I'll be spoiled for any others now. And for the very, very warm welcome we've been given. To be asked to offer some comments on such two excellent presentations is a tall order. In fact, I do find it will be difficult to offer meaningful insights given the deep expertise of Professors GiraudEau and GOODMAN, and indeed the sophistication of the analysis they have offered. To prepare for today, I looked up descriptions of what it is to be a discussant, a role I have not often played compared to being a speaker. I discovered, and I wanted to do a good job, so I discovered that I am expected to highlight the key points of the two presentations, but more importantly, I am to raise questions to hopefully stimulate discussion between the presenters and members of the audience. I think my role is rather that of a devil's advocate, which the Oxford Dictionary describes as someone who expresses a contentious opinion in order to provoke debate or test the strength of the opposing arguments. I will therefore try to do justice to the two presentations we've just heard and the wonderful ideas, but to test the strength of some of the arguments put forward by Professors GiraudEau and GOODMAN. You will see that I rather agree with them. To turn to Professor GiraudEau's excellent presentation. Professor GiraudEau described the EEZ as a major innovation of UNCLOS and explained that it established a balance between sovereign rights and freedom, between the rights of the coastal states and the rights of third-party states. I was struck that in her abstract, Professor GiraudEau described this as a perilous balance, full of danger or risk. And in her presentation, she asked whether this balance is sustainable given the current challenges facing this institution. In essence, Professor GiraudEau was asking us to consider whether the UNCLOS EEZ regime and the balance it establishes can adapt to new realities and cope with a slew of emerging challenges. Using the material approach, she identified one of the two approaches she suggested. She identified and briefly explained a number of issues and difficulties currently confronting the EEZ's regime. The vagueness of Article 74 for the delimitation of disputed EEZ areas, sea level rise, and its impact on existing EEZ boundaries. Indeed, she questioned the very permanence of the EEZ in this context. Referring to climate change, she mentioned the overexploitation of fish stocks and the difficulty of maintaining effective control of the EEZ. And there were others, the general protection of the marine environment, issues connected to seabed, exploration and exploitation. And one that actually also came up in Professor GOODMAN's presentation, competing use of space and referring to energy in this context. She mentioned also security. And in the end, she left us with quite actually a dramatic question. is there a general threat to the relevancy of the law of the sea, I think. I would offer two general comments, perhaps slightly controversial, but I'm not sure. First, I would argue that it should have been expected that the newly created EEZ regime would be tested, that the rules that came into force in 1994 would be variously interpreted, and that kinks in their application would have to be ironed out in time through state practice and the establishment of common understandings, especially through judicial decisions and opinions. I know that we are here to celebrate 30 years of UNCLOS coming into force, but while this is undoubtedly an important milestone, it is not such a long period when one considers the evolution of the law of the sea. One need only look to the regime governing the territorial sea, which we spoke about this morning. The territorial sea is considered la grande dame of the law of the sea, one of the oldest and most enduring concepts of the law of the sea. And yet, how long did it take to agree to a maximum extent of the territorial sea, to work out an acceptable compromise between diverging interests and priorities to enable us to arrive at a generally acceptable solution? And to use one of Professor Géraldaine's examples of competing uses, states are still arguing about competing uses and priorities in the territorial sea. Consider as only one example, the clash between the security priorities identified by some coastal states and the legal rule guaranteeing the right of innocent passage for all vessels, including, I would agree, foreign warships. This example and challenge posed brings me to my second general comment. I fear that the challenges, problems, and issues identified by Professor Géraldine are not only causing problems for the EEZ regime, calling into question its very capacity to remain relevant. I think many of those issues are also impacting other maritime zones. Sea level rise, for instance, is challenging the stability of all maritime limits and boundaries, including the territorial sea baselines. The problem of overexploitation is another issue that is afflicting not only the EEZ, but also the high seas. And therefore, as her last point made clear, Professor Géraldine may be calling into question the sustainability not only of the EEZ regime, but of UNCLOS more generally. And though I think there are most certainly risks, to come back to that word perilous, that I think the more challenging aspects of UNCLOS must be given more time. After all, significant progress has been made to flesh out and build common understandings on some of the challenges she raised. Examples include how the three-step approach, thanks to the pen of judges, has come to dominate the interpretation of Article 74. Another example that's been highlighted already today is the lead taken by Pacific Island states in the regional customary rule, I would argue, that is emerging or has emerged from their general approach and practice, that baselines, limits, and boundaries, once established according to international rules, should be fixed and immutable. I suppose then, and honestly, a little to my surprise, I am fairly optimistic. I think the EEZ regime and UNCLOS can adapt and therefore be sustainable. I would offer a final example in support of this rather optimistic conclusion, the continental shelf regime. Consider how the continental shelf regime, launched by the Truman Proclamation in 1945, nearly 80 years ago, has adapted to new challenges. The very definition of what constitutes the continental shelf of a state had to be revised. Indeed, the rules had to adapt in the face of new technological developments and the stress and impact they had on the exploitability criterion under the 58 Convention. And yes, the new regime under Article 76 of UNCLOS has created new uncertainties, but they are slowly and I think steadily being resolved, including through the assessments and interpretations of the Commission on the Limits of the Continental Shelf, for example, on the differences between oceanic ridges, submarine elevations. Turning to Professor Goodman's fantastic presentation. So Professor Goodman also focused on this central idea of balancing of interests, and as she stated, the concept of the balance of interests features prominently in almost every discussion of the EEZ. And in her presentation, she highlighted fundamental complexities within what UNCLOS seems to present as a supposedly straightforward framework. She addressed a number of specific questions to illuminate these complexities. What is precisely the balance of interests established in the EEZ? Which interests are relevant to this balancing exercise? By what process are such interests to be balanced? And what might this balancing exercise look like in practice? And closely connected to that last question is, should that balancing exercise change over time? In my remaining minutes, I would like to focus on Professor Goodman's second question, what interests are relevant? And on her final question, should that balancing of interests change over time? Because to my mind, those two questions are closely related. In addressing question 2, Professor Goodman explained that interests must be understood as both rights and duties using the case law, and that therefore the balance established in the EEZ regime is a balance between those things that states may do, their rights, and those things that states must do or must not do, duties. She then added another layer, referring to the legitimate interests of the states and that they have a role to play in that balancing exercise. And significantly, that legitimate interests are things that affect rights and duties. Finally, Professor Goodman explained that the balancing exercise must weigh 1, the nature, 2, the importance, and 3, the impairments of rights, duties, and interests. And I think in that reference to interests, it was to those legitimate interests. I would note finally that Professor Goodman's slide emphasized that a consideration of alternatives, of what alternatives are available, should also factor in. So in terms of that question 2, the nature, importance, and impairment of rights, duties, and legitimate interests must all be factored into the balance. The inclusion of legitimate interests as a core element, and with that list that she showed us from the Arctic Sunrise, I think is of immense interest. Because for me, the concept of legitimate interests is not a static concept. Therefore, if the EEZ regime in that balancing exercise calls for a balance of rights, duties, and legitimate interests, that balancing exercise is bound to change over time. That final question raised by Professor Goodman. I would argue, and I'm a little shy to do so, I'm not sure I actually believe, but here goes. I would argue that perhaps globally impactful developments like climate change and its devastating effect on marine ecosystem health, including living resources, and other challenges like the global plague of overfishing, are perhaps having a greater impact on the legitimate interests of the coastal states as they were envisaged in 1982 than on the freedom of navigation. I think Professor Goodman's example of the use of wind farms is fascinating. The statistics in terms of ocean space that will eventually be covered by wind turbines is staggering. And yet, I still feel that the two interests can be accommodated, that using the established rule of respect for sea lanes is essential for navigation, the importance of coastal states' rights to, but especially their legitimate interests in clean energy, can be reconciled with the efficiency and safety of navigation. If one considers the question of impairment in the sense of the availability of alternatives and the alternatives, wind farms are absolutely essential to the global effort to reach net zero emissions, as she informed us. Whereas perhaps developments in AI and new ship operating technologies may help ships continue to navigate efficiently and safely, even in crowded oceans. I'm not saying that states will no longer enjoy the freedom of navigation in the EEZ. I'm not that daft. But perhaps the balance of rights, duties, and especially the legitimate interests of the coastal states, especially when you think of environmental and biodiversity interests, which in many instances will be aligned with broader international community interests, may tip the balance slightly, at least maybe on an issue-by-issue basis. As you mentioned, it is not a universal objective test. As Professor Goodman's last slide emphasized, the balance of interests in the EEZ is developing, and it must develop over time to respond to social, economic, political change, to new advances in sciences, including our scientific understanding of phenomena like climate change and its effect, and also technological developments. I am in complete agreement with her last point that the balance is not fixed, that the competing rights, duties, and legitimate interests will need to be regularly or periodically reassessed and new balances struck repeatedly. As I mentioned in my comments on Professor Géraldaine's presentation, although I acknowledge that working out these new compromises can be slow and somewhat messy, I think it's absolutely necessary to do so and that it is achievable. I have in mind the example, I had written already the example that Judge Hader gave us this morning, our emerging understanding of where the balance lies for the bunkering of different types of ships in the EEZ, thanks in large part to judicial pronouncements. UNCLOS is a constitution for the oceans. Several people have underlined already at this conference that it is a living instrument. In its truest sense then, if it is a living and breathing document, which I'm borrowing the words of Eric Fan, it is a dynamic framework designed to adapt and evolve. It allows for bounded resilience. It must, however, be allowed to breathe and grow. So let me here end by thanking Professor Géraldine and GOODMAN on behalf of us all for their thought-provoking and insightful presentations. Thank you.
Thank you, Professor Lalonde, for your insightful discussion on the issue. And I'm sure that you've raised issues that the audience will also like to participate, because based on the issues that you raised, in my personal view, I observed that 3 themes run through all the presentations. Jurisdiction, security, and of course, international cooperation. They are very important in managing the EEZ. With that note, let me call upon our final discussant for this panel. Her name is Professor Kim Hyun of Yonsei University. Dr. Kim Hyun is a professor in the Department of Political Science and International Studies at Yonsei University, Republic of Korea. Her primary research areas include the law of the sea, climate change, international institutions, and the intersection of international law and policies and politics. She has published extensively in Korean, English, and French, contributing significantly to the field of international law. Okay. I think this is enough to describe Professor Dr. Kim Hyun. You have the floor.
Thank you, Chairperson. Good afternoon. My name is Hyun Kim from Yonsei University. First of all, let me express my sincere gratitude to MOFA Korea, EEZ, and Korean Society of International Law for inviting me to this wonderful event. Our session today is titled The Legal Regime of EEZ under UNCLOS. When I teach international law of the sea, I spend a lot of time explaining the EEZ because it is one of the most significant maritime zones under UNCLOS. Our 2 speakers, Professor Géraldine and Professor GOODMAN, explored the formation of EEZ and balance between coastal and flag states' interests and the challenges facing the EEZ regime. Thank you both for your insightful presentations. Let me give by making a few comments on the presentations and connecting them to Korea's practice related to EEZ. First, the EEZ is an artificial zone, unlike the continental shelf, which was originally based on geographical and geological factors. During the 3rd UN Conference on the Law of the Sea, states did not agree on the 200 nautical mile limit for any scientific or ecological reason. Rather, this distance was a political compromise. As Professor Géraldine put it, the EEZ is a great innovation of UNCLOS. Second, Professor Géraldine also emphasized the Global South's role in shaping the concept of the EEZ. I'd like to add that Korea also contributed. In 1952, the Korean president issued a presidential decree known as the Peace Line, extending 50 to 100 miles off the Korean coast. This was mainly to protect Korean fishermen from technically advanced Japanese fishing activities. In many ways, this reflects the modern EEZ's purpose to safeguard coastal states' economic interests. At that time, the United States and Japan expressed their opposition to Korea's declaration of the peace line on the grounds of freedom of fishing on the high seas. Although the peace line faced opposition at that time, it contributed to the development of concept of EEZ. In terms of formation of customary international law, it is interesting to note that actions initially seen as inconsistent with the existing rules can over time contribute to the development of a new customary rule, especially when supported by consistent state practice following. In this context, Korea's peace line declaration in 1952 can be viewed as an early example of a state practice that aligned with and contributed to the eventual formation of EEZ concept on the UNCLOS. Third, both speakers also mentioned offshore wind farms as growing challenges to the EEZ regime. For example, earlier this year, the Japanese government introduced a bill to Parliament to amend the law regarding offshore renewable energy generating facilities. This bill seeks to expand the areas where offshore wind farms can be developed, moving beyond Japan's territorial waters, its EEZ. Korea is also making efforts to establish offshore wind farms in its EEZ. Currently, there is no dedicated law specifically for offshore wind farms in Korea. However, the Korean government is actively promoting the development of offshore wind farms. According to an announcement made by the Korean government in this August, 61.1 gigawatts of energy is projected to be supplied by solar and wind power by 2030. In addition, the government plans to expand wind energy capacity by another 1.9 gigawatts by 2030 through policy efforts. These include measures to simplify the licensing process for offshore wind projects. Through these initiatives, Korea aims to achieve a carbon neutral scenario before 2050. However, such developments raise practical and legal issues. For example, foreign vessels involved in wind farm construction in the EEZ may also need to enter Korea's territorial waters or ports. However, under Korean law, some ports are restricted to foreign vessels. Should these restrictions be lifted for long-term projects like offshore wind farms? At the same time, large-scale wind farms may also affect local stakeholders, such as fishermen, because these farms are likely to restrict their fishing activities as well. Environmental concerns are another challenge, as Professor GOODMAN also addressed. Wind farm construction can cause underwater noise, sediment disturbance, and electromagnetic waves, which affect marine ecosystems. For instance, low-frequency noise can disrupt marine mammals like dolphins. And we also have dolphins in Korea. While offshore wind energy is key to combating climate change, we must ask whether it creates new environmental issues that need to be addressed. Finally, when two states have overlapping EEZ claims, an undelimited area arises. In such cases, UNCLOS Article 74, Paragraph 3 provides that states shall make every effort not to jeopardize or hamper the reaching of a final agreement for delimitation. However, this raises an important question: to what extent can states exercise their rights in these undelimited EEZ areas? Ultimately, this is another example of the challenges of balancing competing interests, this time between the claimants themselves. The issue of what constitutes a breach of Article 74, Paragraph 3 has been addressed in cases like Guyana-Suriname arbitration and the Ghana-Côte d'Ivoire case before the ICLS Special Chamber. Even so, there is ongoing debate about whether disputes regarding this obligation are included under, I quote, dispute concerning the interpretation or application of Articles 15, 74, and 83 relating to sea boundary delimitations, end of quotations, as described in Article 298, paragraph 1A1 of UNCLOS, Part 15. Another point of discussion is whether a violation of the obligation of a restraint for fishing activities in an undelimited EEZ qualifies as dispute relating to the coastal state's sovereign rights with respect to the living resources under Article 297, paragraph 3A of the Convention. If it does, such disputes should not fall under the compulsory procedures in Part 15, Section 2, but instead would go through the conciliation process outlined in Annex 5, Section 2. With these legal uncertainties in mind, I would be interested to hear presenters' thoughts on how disputes on delimited EEZ areas should be addressed under Part 15 of UNCLOS. I know we have another panel for the peaceful settlement of disputes, but if you have any thoughts about this issue, I would like to listen to that. Once again, I'm very grateful to our speakers for their excellent presentations, and thank you for listening to my discussion.
Thank you, Dr. Kim. That was very, very fast. Now we've listened to our excellent panelists. They have a multilinguistic perspective about the law of the sea, especially on the topic under discussion. If you can see from their bios, most of them speak, I'm sure, 2 or 3 languages. Like for Kim, she speaks Korean, French, and English. And the one nearer to her, the next, speaks English and French. And of course, my immediate left, she speaks French and English as well. So they have multilingual perspective about the EEZ. Now I open the floor for your contributions, comments, interventions, and questions.
Thank you very much, James Harrison, University of Edinburgh. I enjoyed those presentations immensely. I have a question for Dr. Goodman. You gave us an interesting view on how the balance should be struck. I think my question is a bit more about who strikes that balance. And I guess the relationship between courts and states. When courts are seized of these sorts of disputes, what exactly are they doing? Are they checking that states have followed the right sort of process? Are they asking whether a reasonable balance has been struck? Or are they stepping in and saying what the right balance should be?
Well, thank you for that question. And I might also take the question from my fellow panellist here as well, which had some similar flavours to do with disputes and undelimited maritime boundaries. Just as a broad comment, the thing I really like about balancing of interests, and particularly the test that was set out in the Chagos arbitration, is it speaks to me as a government lawyer. That's the same way that we would address a policy issue at the domestic level, right? You would think about what you're trying to do, who it affects negatively, and whether there's any other way that you might do it that would affect people differently. So I really like the way that that test was translated to the international plane, and I think it can be used by everybody. So in terms of who does the balancing, the first part of the question, I think everybody does the balancing. I think states do the balancing in their own actions when they're choosing what law to pass or not pass, or what jurisdiction to assert or not. I think the sort of process that I've described could be incredibly useful in the case of a disagreement between two states wanting to sort it out themselves through a process of negotiation, as a way to, legitimately identify all the different perspectives and map everything out, and essentially almost do that domestic policy process of working out the best solution for everybody, taking the best, most optimistic, good faith approach, I suppose. And in terms of courts and tribunals, I think it depends what they're being asked. And sometimes I think they do look at the process. I think in Chagos they were looking at the process and had consultation been undertaken, for instance. So sometimes it is a process issue. At the end of the day, often it is a substance issue, and a question of whether the balance was struck in the right place. But there are all different sorts of balances. So the balance in a prompt release case is a very different sort of consideration to the balance in a arrested vessel case such as Virginia G, or the balance of, you know, broader sort of IUU fishing issues. So this isn't going to apply the same way in any instance. My objective here is really to try and raise up rights and duties to the same level so that due regard doesn't come in as a sort of second afterthought after the rights are established. Oh, and we better think about due regard. I think thinking about those things on the same plane is useful, and then I think thinking about them for everybody that's involved at the same time to try and resolve the best possible outcome is useful. And I suppose I'm conceiving balance of interests almost as a sort of a meta concept above the Law of the Sea Convention. The Law of the Sea Convention seeks to establish a balance of interests. It does that by enunciating rights and duties, and those rights and duties are then interpreted in the balance of interests, so there's almost a sort of virtuous circle. In terms of undelimited areas and dispute settlement, I claim no expertise, but I am an ex-government lawyer from Australia, and I was involved in early stages of the Australia and Timor-Leste case, so I do think that we have now an excellent example of the possibilities to use conciliation in a very positive way. And I know I don't speak for the Australian government in any way, shape or form, but Australia has long held the position that boundaries are best solved through negotiation. And I think the Conciliation Commission did a wonderful job of being able to draw in all the different interests, rights, duties, perspectives, and come out not just with a line, but with a solution that worked for everybody.
Thank you for those answers. Any comment on your side?
Just a few comments, thank you. I would like to thank Professor Lalonde and Professor Kim for their comments and their insightful points. Maybe I would just like to answer briefly to Professor Lalonde, who made a point, because indeed, lots of these challenges, climate change, other threats to environment, security, are not specific to EEZ. But I would say that the causes are the same, but the effects are different, for at least 3 reasons. The first one would be the ambiguities of the dispositions specific to EEZ, which are more important because it's a sui generis regime and because also of historical reasons for the project I've mentioned initially of creating a unique zone with the continental shelf. 2 other things would be the vastness of these maritime spaces and what is at stake in terms of biological diversity and economy. As I reminded to 90% of the fish market comes from the EEZ. What EEZ means for small island states is an existential aspect. So it also means that, for instance, if we think about permanence of maritime zones, if we focus on permanence of EEZ, it is indeed an existential issue for some of the countries.
Thank you. Any additional question, comment? We still have like a few minutes, at least 5 minutes more. Okay. You have the floor.
First of all, thank you for the excellent speech and perspective. It was really impressive. So I'm a sophomore in Korea University, majoring in international studies. So I have a question to Dr. Goodman. Professor mentioned that rights, duties, and legitimate interests must be balanced. So I have a question in this point. I think from a state's perspective, it seems likely that they would focus on interest when addressing matters related to the EEZ. So could you please elaborate further on how this balance can be achieved in practice?
You have the floor. Go ahead.
Oh, thank you for the question, and it's great to see you here at the conference and to be able to engage with so many people from different areas of study and different universities. I think in my ideal world, in order to achieve the balance, states would conceive of examining their rights and examining their own duties and doing that real balancing process that I've described in the presentation to make sure that the rights they're asserting meet their needs and fulfil their duties, and also align with that broader idea of what benefits everybody. Because the translation of rights and duties into the law of the sea convention is part of this grand bargain, the consensus deal, the package deal, that everybody accepts all the rights and all the duties and that there are no reservations. So, a good faith implementation of the convention would look not only when states want to do something at what they're allowed to do, but also what they're required to do in giving effect to it. That's quite a difficult task, and it probably draws in more than one government agency into decision-making processes. So, as we know, it's hard working in government, trying to work across silos, and if you're trying to make a decision about fisheries and you have to consult with the Transport Agency and the Communication Agency and the Navy and the Environment Department. So I think coordination and breaking down silos within government is also a really important part of being able to do that in a practical way.
Thank you for those answers. I think one final contribution from the floor. Yes.
I'm a second secretary from the board, KMOFA, Chino Park. I would like to have a question to Professor Géraldine. Although it was discussed in the first session, you have also discussed about the articles in UNCLOS and referred to submarine cables. What is your maybe an opinion whether concerning subcables that whether there should be a kind of a additional legislation, or maybe do you think the regime of UNCLOS is sufficient to regulate those kind of subcables matters? And finally, you also referred to the notion of due account in your presentation. So if possible, could you give some more details about that notion? Thank you.
You have the floor, Professor Géraldine.
Thank you. So these are, thank you for your questions. Very vast ones, because on this matter, it's obviously not only about the EEZ. So regarding cables and pipelines, there would be a lot to say, so I'm afraid I won't be able to assess the whole question in just a few minutes. But I do think the regime is substantially insufficient because the threats regarding the cables and pipelines, especially the submarine cables, are different, diverse, and the dispositions as we have them right now don't take into account the diversity of actors, of activities that are needed into the installation, maintenance of those cables. So different reports, I mentioned the work of the International Law Association and the group dedicated to that issue. There were also, who's currently co-managed by Tara Davenport, who's here. And so there are already several reports, pre-reports that have been published. And so a third one, which is in its way. So hopefully such a work and also other ones will allow some reflections and some evolutions to that regard, which is of high interest, including for this region, including for the potential harms, intentional harms to the submarine cables in the Asia-Pacific region. Regarding of the due, I'm not sure I can answer it just like this to the question of due account and due regard, because it's such a big topic. I would just maybe comment that it's obviously a difficult notion to assess, and that the work of the international judge has been crucial to that regard. And some clarification, further clarification will probably be needed. I don't know if some of my colleagues want to add something on this. No. Or maybe we can discuss this further.
Thank you. Let me thank my panelists for the wonderful presentation. But if I may say one or two words concerning the issue on insufficient provisions on regarding submarine cables. As you heard from previous speakers here, that UNCLOS is a constitution for the oceans. With respect to security threats to submarine cables, that can be addressed through international cooperation, using specific provisions or the umbrella, or even the preamble of UNCLOS, which talks about peace and security, to ensure that there is international peace and security. So you negotiate through international cooperation. That's why if you listen to what I just mentioned, 3 important themes run through the presentations: security, international cooperation, jurisdictional issues, sovereignty. These are the key issues or key themes that run throughout all the presentations. With respect to submarine cables, the only means for now that the international community should address that issue is through the negotiation of a protocol, like what we did with respect to the armed robbery at sea, the SWA Convention, and then you have also on piracy. So these threats could be addressed through negotiating another treaty under the umbrella of UNCLOS, because UNCLOS being the constitution of the oceans, we can negotiate an international agreement that UNCLOS subsumes for the implementation of any threats regarding the security of submarine cables. I think that could go a long way to address that issue. Just yesterday, I heard that there are issues of the cables lying between Finland and Europe. I'm sure most of you must have heard that. So the way to address these issues through international cooperation. It's very difficult to modify UNCLOS for obvious reasons. Maybe when attempts are made to modify it, what is there we may not come out with what is there already. Looking at the challenges we encountered in negotiating UNCLOS, so it becomes very, very difficult or cumbersome to make any attempt to modify UNCLOS. So that being said, let me thank you, esteemed panelists, and also participants for your enlightening contribution to our discussion on the EEZ. This discussion has underscored the complexities and opportunities surrounding this vital maritime concept. As we conclude this session, let us remember that the EEZ is a critical component of the law of the sea, balancing the interests of coastal states with those of other states. We must continue to work together to address the challenges arising from the EEZ, including environmental concerns, maritime security threats, and the need for international cooperation. So we need international cooperation in addressing any cumbersome issues within the EEZ. I thank you for your kind attention.
Thank you very much, Judge KAMARA, and my gratitude to all of our panelists for the discussions. Ladies and gentlemen, please applaud all the speakers, including Judge KAMARA for being a great moderator.